Dear friends, we are here to discuss something about the matrimonial disputes. Matrimonial disputes today are one of the common cases which are being heavily flooded in the courts all over India. For the purpose of resolution of the disputes of the matrimonial cases, the government have enacted the Family Court Act, by which family courts have been given exclusive jurisdiction to deal matters relating to family disputes. Now, family disputes prima facie relate to the disputes between husband and wife and relatives of husband and wife. In this discussion, I would like to discuss the main provisions of the Hindu Marriage Act, which specifically deals with the relationship between husband and wife. For getting deeper into the discussion, it is essential that first we should know what is the provision relating to marriage under the Hindu Marriage Act. The Hindu Marriage Act was enacted way back in the year 1955, and it provides that the act only extends to Hindus. It do not extends to Muslims, Jews, Parsis, Christs. It exclusively deals with Hindus, which include Sikhs, Jains, etc. Now, Section 5 of the Hindu Marriage Act also specifies certain conditions relating to validity of a marriage. Once you go through the litmus test of being a Hindu and having a valid essential marriage, then you can claim rights under the Hindu Marriage Act 1955. Now, Section 9 of the Hindu Marriage Act is very essential for both the spouses. It says restitution of conjugal rights. By restitution, we mean that the social institution of marriage should be restituted if one of the spouse desert the other or do not obey its marital obligations. Then the other spouse can go to the court of law, can go to the family court and get its claim redressed, whereby the family court will pass a decree under which the other spouse can be forced, or more appropriately can be decreed to live together with the spouse and obey his or her matrimonial obligations. Furthermore, Section 10 of the Hindu Marriage Act provides provision relating to judicial separation. What if in a situation that no spouse can live with the other spouse? The court under Section 10 of the Hindu Marriage Act 1955 can grant a decree of judicial separation. It do not create the institution of marriage to an end, but yes, the rights of cohabitation can be stayed by the court of law. Then the concept of void and voidable marriages under Section 11 and 12 of the Hindu Marriage Act. Section 11 of the Hindu Marriage Act talks about void marriages. Void marriages and voidable marriages. Void marriages are the marriages which are void ab initio, and voidable marriages are the marriages which can be continued if even of the parties agree, both of the parties agree to continue their marriage. Section 13 of the Hindu Marriage Act 1955 is one of the most used provision in the court of law family courts. That has the grounds of divorce available to both the parties, means both the spouses, the husband and the wife, and more appropriately under subclauses of Section 13 there are certain rights which are exclusively available to the wife.